Yes.
Yes, Lordship, with the consent of the respondents, Lordship, I beg to mention item number 8, Lordship. Lordship, my seniors, Mr. S. Borgoha is having difficulty, Lordship. And Lordship, if this matter will be fixed on 29th of the July, Lordship, after the summer vacation, Lordship.
You are for respondent number?
I'm the petitioner, Lordship.
Oh, okay. Okay. You inform the other side?
Yes, Lordship.
Your good name, please?
B. Chakma, Lordship.
Mr. B. Sakma, learned counsel for the petitioner with consent from the other side. Rise for listing the matter on 29th of July.
July. Yes.
Fair allowed.
May it please, Your Lordship. All right, I'm seeking Your Lordship's indulgence in respect of an unlisted matter, where there is some urgency in this case because my shop has been kept under lock and key. In fact, we had filed this case last Thursday, and it's yet to be listed. It's only for issuing notice, no interim, nothing.
When?
For today, as the last item, my Lord. Deeply obliged.
Seek Your Lordship's indulgence in making a mention of item 1 of part 2. Hearing list, my Lord. The conducting counsel, Mr. Sidaram Zau, is unable to attend due to some personal difficulties.
Item number?
1 of part 2.
Okay.
So if this matter may come up after the ensuing vacation.
After summer vacation.
Yes, my Lord. And in the meantime, if we may be allowed to file a rejoinder affidavit to the affidavit in possession of respondent number 4.
You are for the petitioner?
Yes, on behalf of
learned
Mr. Sidaram Zau.
Mr. Swinson, learned counsel for the petitioner with consent from the other side. Price for listing the matter after vacation.
Yes, my Lord.
After vacation, he also submits that he may be allowed to file rejoinder affidavit
Yes, ma'am.
against the affidavit filed by the respondent number
4.
4. Fair allowed. This shall list the matter immediately after reopening of the vacation. And in the meantime, the petitioner shall file the rejoinder affidavit.
Obliged.
My Lord, may I mention part 2, item number 7?
Item number
7.
7.
My Lord, I'm going to file my power in this case along with the no objection certificate from the previous council. I'm
You are for the
I'm for the new council for the petitioner.
petitioner.
Yes.
Okay.
Today I'm going to file my power.
Okay.
Then may this matter be listed after
So
4
learned
weeks.
counsel for the appellant submits that she has newly been engaged in this matter and will be filing her power during the course of the day, and she pays for listening the matter after
4 weeks.
after
4 weeks.
after 4 weeks.
Much
Fair
obliged.
allowed. Fair allowed.
For motion, item number 1. May it please, my Lordship. My Lordship, this is a writ petition challenging the suspension of village council in Lai Autonomous District Council, my Lord.
Yes.
My Lord, before suspension, there's a notification dated 15 May 2026, which is in page 102, my Lord.
Yes.
Just thinking. And the English translation is in page number 103. It's in annex 14, my Lord. May I read out, my Lord? Page 103, my Lord. English translation. May I read out, my Lord?
So there are two notifications
One
which are
notification.
being challenged. One is of dated 15th of May 2026 and the other is dated 18th of May 2026.
Yes, my Lord. 15th of May is appointment of inquiry commission. And 18th of May is the suspension of the village council,
That
my
is
Lord.
also the subject matter of challenge in this petition.
Yes, my Lord. Board, I'm challenging board notification, my Lord.
Okay, let notice go.
My Lord, I'm seeking stay of the board notification, my Lord. Since the suspension is only for 3 months, my Lord.
Suspension is
only for 3 months, my lord.
Yes.
So I'm seeking stay of the notification, my lord.
Suspension is only for 3 months.
Yes, my lord. The date, the suspension order is 18 May 2026, and it's only for 3 months, my lord. And I'm seeking stay of the notification, both notification, my lord. 15th May and 18 May.
No, 3 months is yet to elapse.
But during the pendency, my lord, it will just lapse if no stay is granted, my lord. It will be infructuous, my lord.
Yes.
Lordship, if I may, if the stay of operation of the notifications are ordered, the very reason of the suspension, there is to conduct inquiry on the basis of principle of natural justice will be defeated. So I pray not to stay the notifications. Lordship, all the notifications, the inquiry, and everything else was done in accordance with law. Therefore, I kindly pray.
So no interference is required, according to you. Yes, what is your
My lord,
reply?
if I may take my lord to page number 67 of my petition, my lord.
67.
67. Last para, my lord. Amendment of section 10.
Yes.
Amendment of section 10. For section 10 of the Principal Act, the following shall be substituted, namely, dissolution of village council. And the relevant part is in 10th one, my lord. Next page, 68. May I read out, my lord?
10?
10th one, page 68, my lord.
Yes.
The executive committee may appoint a commission consisting of not more than 3 persons from amongst the officers of the district council to inquire into the affairs of the village council if it considers reasonable on a complaint in writing that the village council is too inefficient or is unable to carry on the village administration or is acting in a manner prejudicial to the interests of the state or the district council or is known to have been indulging in corrupt practices in the manner of village administration. My lord, there are only 3 grounds, according to this act, there are only 3 grounds for dissolution or suspension of the village council. The grounds are, my lord, here, is too inefficient or is unable to carry on the village administration, number 1.
Number 1 is?
Number 1 is if the village council is too inefficient or is unable to carry on the village administration, my lord. Number 1. Or number 2 is acting in a manner prejudicial to the interests of the state or the district council.
Yes.
Number 3 is if the village council is known to have been indulging in corrupt practices in the manner of village administration, my lord. And my lord, if I may take my lord to the suspension order. First, the 15 May 2016 notification, my lord.
Page number?
Page number 103, my lord.
103.
May I read out, my lord? Page 103, my lord. Annexure 14A,
Yes.
the English translation. Notification 15 May 2026. Since 2 letters have been received by the local administration department, Lai Autonomous District Council, from the Young Lai Association Ngeng Pui Kai branch, and from 3 members of the Ngeng Pui Kai Village Council, so-called notices dated 24th April 2026 and 5th May 2026 have been issued to Ngeng Pui Kai Village Council, giving them an opportunity to give clarification, explanation regarding the points raised in the complaint. Though replies to the so-called notices were submitted by the President and some members of the Ngeng Pui Kai Village Council within the prescribed time, in this regard, the Executive Committee of the Lai Autonomous District Council cannot accept the replies submitted by the President and colleagues of the Ngeng Pui Kai Village Council. Therefore, the Executive Committee of the Lai Autonomous District Council, in order to verify the complaints regarding the work and administration carried out by the Ngeng Pui Kai Village Council President and his colleagues, and for better administration of the village, in exercise of the powers vested under Chapter 2, Section 10, Subsection 1, 2, and 3 of the Lai Autonomous District Village Councils Act 2010, as amended from time to time, has hereby constituted an inquiry commission comprising the following. Next page, man.
Yes.
Executive committee appoints 3 persons, my lord. And here, inquiry commission must follow proper procedure and make inquiry without any discrimination as per Section 10(2) of the Lai Autonomous District Council, Village Council Act 2010, as amended from time to time, and such inquiry report must be submitted within 3 months from issuance of this letter to the Executive Committee, Lai Autonomous District Council. My lord, here in even from the appointment of the inquiry commission, there is no reasons or points mentioned in the act. The 3 points which I just read out, my lord. It's just that since they cannot accept the reply made by the village council president, inquiry commission has been appointed, my lord. And in 105, page 105, my lord, the suspension order, my lord. Translation is in 106.
Yes.
Here again, since 2 complaints have been received from Yang Lai Association Ngeng Pui Kai branch and members of MNF village council members regarding the functioning and administration of the village, the local administration department, Lai Autonomous District Council, issued a show cause notice to the Ngeng Pui Kai Village Council. The show cause notice has been replied to by the president and colleagues of the Ngeng Pui Kai Village Council. Since the executive of the Lai Autonomous District Council, the reason here again mentioned here is, my lord, since the executive committee of the Lai Autonomous District Council cannot accept the replies submitted by them, inquiry commission has been constituted via notification dated so and so. The above being the case in hand as required by Chapter 2, Section 11(1) of the Lai Autonomous District Council, Village Council Act 2010, as amended from time to time, which provides for suspension of village council during inquiry. The executive committee of the Lai Autonomous District Council has suspended Ngeng Pui Kai Village Council, and the period of suspension shall includes until the submission of the report, final conclusion by the inquiry commission. Hence, next page, my lord. Hence, the executive committee of Lai Autonomous District Council, with the powers vested under Chapter 2, Section 11, 2, sub-clause 2 and 3 of the Lai Autonomous District Council Act 2010, has hereby constituted forthwith caretaker comprising the following to look after Ngeng Pui Kai Village Council as interim during this suspension. My lord, in both notifications, there was no mention of the points mentioned in Section 10 of the amendment, my lord. Here, as I submitted, my lord, earlier in page number 68, there are only 3 points for suspension of village council. And those points were completely not mentioned in both notification, my lord. And even the allegation was not that thing, my lord.
You know, whether the third point, yes,
Third
or
point
is known to
is
have
known to have
been
been indulging in corrupt
in
practices in the manner of village
So
administration, my
the
lord.
complaint has been received against the village council.
Yes, my lord.
Where is that complaint?
Complaint. First, show cause notice in page number 71, my lord.
No, I am asking you about the complaint. Is it part of the record?
Yeah, it's here at page number 74, my lord.
74.
Page number 74 is the English translation, my lord. Shall I
That
read?
is the show cause notice.
Show cause notice in page 71, my lord, and the complaint is annexed along with the show cause notice, my lord. 71 is the Mizo version, my lord, and the translated version is in page number 73.
74 is the show cause notice.
No, my lord, 73, the English translation of the show cause notice is in page 73, my lord.
Okay.
May I read on, my lord? As stated in the above subject matter, mentioned subject, complaint has been received against you in respect of the work executed as being Ngeng Pui Kai Village Council President, Village Council Member. Take notice that you are directed to submit a written reply to the complaint attached along with this letter received against you within 6 days from issuance of this letter, and also to show cause as to why action shall not be taken against you to the undersigned. And the complaint is in translated version of the complaint is in 74, my lord.
So whether the point number 3 mentioned in section 10 is not attracted here,
I don't think it's attracted, my lord, according to me, my lord.
known to have been indulging in corrupt practice. So going by the page number 73, the complaint, it appears that
Here, according to the complaint,
you have given direction to cut trees from the
this is
reserve
just the
water
allegation, my lord.
sources in the village. Additionally, did not return
That it's returned, my lord.
NREX money amounting rupees 16,000 used by him in the last year, and that the president and the village council took all the money. Whether this would not come under the purview of subsection 1 to section 10.
According to me, my lord, it's not,
According to
Yes,
you,
my
it
lord.
is not attracted.
because this 16,000 is it's returned. My receipt is in page number 91, my lord.
Page number
91. Page number 91, my lord. That I have received a sum of rupees 16,000 in respect of the wildlife work fund from village council on dated 25th April 2026.
yes, Mr. Counsel, for the respondent.
Yes, Lordship. Lordship, if I may, in this matter, complaint in writing is lodged before the executive committee, not only by the Young Lai Association, which is the largest non-governmental organization in that village and in the particular area, but also by other members of the other elected members of the village council itself, which can be seen from page number 72 of the petition. Lordship. Taking to the English translation is at page 74. Lordship, your friend has already read most of them. The receipt which he talks about, the receipt of paying 16,000 is at page 84. But your lordship, I would like to take you to page number 72 simultaneously with page number 84. Receipt is made after the complaint is lodged. Complaint is on date 6/4/2026. The receipt of page number 72. The complaint is made on 6/4/2026. And lordship, if I may take you to page number 84. The receipt is dated 25/4/2026. The receipt is not made prior to the complaint, your lordship. In fairness, I would like to mention that. And next, lordship, I would like to take you to the page number 76 of the petition. This is the complaint submitted by other elected members of the village council.
76.
Yes, lordship. The English translation is at page 78 of the petition.
Yes.
If I may read out the permission, Lordship. Page number 78. Request to suspend Miang Kai Village Council. Due to the following points mentioned below, I request to conduct inquiry against Miang Kai VCP and take actions as required. Number one of the complaint by the other members of the village council is with regard to PMA voice election. The ongoing village council did not consult any other member of the village council, which is alleged. If I may continue, Lordship, information was also not given. Selection has been carried as per their wishes. This is against PMA rules. Number two, agricultural link road funded by Lahore has been executed as per the wishes of the VCP, but not as per proposal, which is abuse of authority or position. Lordship, I would like to mention that the amended act, section 11, clearly states that the executive committee may appoint a commission consisting of not more than 3 persons from among officers of the district council to inquire into the affairs of the village council. Lordship, this is not the end for the village council of the Miang Kai village. This is just the suspension during inquiry. And the suspension of the village council is not arbitrary in nature. It is made according to law. Lordship, if I may take you to I'll just read out from the petition. Lordship, if I may take you to page number 69 of the petition, Lordship.
Yes.
May I read out point number 4. If on perusal of the report of the commission, the executive committee finds no reasonable ground to dissolve the village council, which is under inquiry, or if the commission has become infructuous as provided under section 10(2), such order of suspension shall be revoked, and the village council shall continue to function as it were immediately prior to such suspension. Lordship, suspension is merely time taken for inquiry, as I have mentioned. If the executive committee finds no reasonable grounds to dissolve the village council, suspension shall be revoked. Therefore, I pray your lordship to kindly dismiss the petition in this case.
My lord, if I may just submit only 2 points, my lord. My lord,
Yes.
suspension order has been passed on 18 May 2026. Until date, no inquiry has been conducted, my lord. I've written a letter on 25th May 2026. It's in Annexure 108, my lord. 108, my lord. Simply notification has been passed, but no action has been taken by LADC, my lord. If I may read that, my lord. It's in 108, my lord. third last page, my lord.
Yes.
Here, my lord, the applicant is the village council president, Nyangpuikai Village Council, recently put under suspension by the executive committee, Lai Autonomous District Council, by notification dated 18 May 2026. The applicant humbly seeks the following information. Number A, whether the inquiry commission formed by notification dated 15 May 2026 has submitted its inquiry report and recommendation for Nyangpuikai Village Council to the executive committee, Lai Autonomous District Council. B, whether the inquiry report and recommendation, if already submitted by the inquiry commission to the executive committee, Lai Autonomous District Council, has ever been furnished to the applicant or any other members of Nyangpuikai Village Council. C, whether inquiry has ever been conducted or carried by the inquiry commission between the period 15 May 2026 and 18 May 2026 in respect of the complaint received from President Yang Lai Association, Nyangpuikai, and some members of Nyangpuikai Village Council against Nyangpuikai Village Council President. Number D, whether inquiry has ever been conducted or carried by the inquiry commission since 28/4/2026. This is the date of the complaint, but till date, in respect of the complaint received from the President Yang Lai Association, Nyangpuikai, and some members of Nyangpuikai Village Council against Nyangpuikai Village Council President. And the reply is in 111, my lord.
So, is there any time frame in respect of completion of the inquiry?
3 months, my lord.
3 months. Yes.
No action has been taken by the inquiry commission, my lord, till date.
Lordship, I will have to consult the matter with the respondents regarding the points. However, Lordship, I think it is very premature to conclude that no inquiry has been taken. The executive committee appointed the commission. They have 3 months to complete the inquiry. So, supply of inquiry report and recommendations very premature. Lordship, moreover, that there is no mention in law that they should furnish the same before submitting the same to executive committee.
Okay.
I'm submitting, my lord, one judgment, my lord, of this honorable court, my lord. Just 2013 for GLR page 217, my lord. Citation reads, my lord, Lai Autonomous District Council, District Village Council Act 2010, Section 10(4) and Section 11(1), suspension of Village Council, power conferred on the Executive Committee to place a Village Council under suspension, being discretionary, has to be exercised objectively and with circumspection. Functioning of Village Council should not ordinarily be interfered with, except when it is inefficient or unable to carry on the village administration, or is acting in a manner prejudicial to the interests of the state or the district council, or is known to have been indulging in corrupt practice. Executive committee may appoint not more than 3 persons from amongst the prominent villagers to look after the village administration in the interim. Power is to be exercised after dissolution of the village council. Prominent villagers could not be a member of the village council dissolved. And the relevant point will be, my lord, page number 221, my lord. Page number 221. May I read out, my lord, again? Page 221, my lord. It's in 5th paragraph, my lord. The act has been framed under paragraph 11 of the 6th schedule. My lord, it's in page number 221, my lord. 21. Page 221 of the judgment, my lord. It's in paragraph number 5. Paragraph number 5, my lord. May I read out, my lord? The Act has been framed under paragraph 11 of the 6th schedule to the Constitution of India to provide for establishment of village councils, their powers, and for matters relating to village administration. And same point is in H, my lord, section 10 of the village, last para, my lord. Section 10 of the Act provides for dissolution of village council. As per subsection 1, the executive committee by public notification may appoint a commission consisting of not more than 3 persons from amongst the officers of the village of the district council to inquire into the affairs of the village council on the following aspects. Number A, the village council is too inefficient. 2, is unable to carry out the village administration. Number 3, is acting in a manner prejudicial to the interests of the state or the district council. Number 4, is known to have been indulging in corrupt practices in the manner of village administration. And again, my lord, if I may take my lord to paragraph number, second last para of this page, my lord, page number 222, my lord. Page 222, my lord, second last para. Just above the second last para, my lord, or last sentence of the preceding paragraph. Thus, under section 11, discretion is vested on the executive committee whether to act or not to act on the recommendation of the commission. Though section 11,
Here the inquiry is yet to be completed. Report is yet to be furnished. So how this decision will help you? Let notice go.
stay may kindly be
We
granted, my
will
lord.
also issue notice in respect of the interim pair. Let him come with proper instruction. Heard, Mr. Your name, please.
Dalwood Pues, Silo.
Learned counsel for the petitioner. And also heard, Mr. Learned counsel for the respondent number
1 to 3.
1, 2, 3. 1, 2, 3. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the impugned notification number Roman 5.110/5/2025/LADC/LAD dated 15/5/2025, by which Inquiry Commission was appointed, form under Sector Roman 2, Section 10(1) within bracket Roman 2, 2 within bracket 3 of the Lie Autonomous District Council within bracket Village Council Act within bracket as amended from time to time, to inquire into the complaint against the Nagan Pokai Village Council in order to create better administration, and also the impugned notification number Roman 5.11012/5/2025 LADC/LAD dated 18/5/2025, by which the Executive Committee, Lie Autonomous District Council suspended Nagan Pokai Village Council Court. The learned counsel for the petitioner, referring to section 10 within bracket 1 of the Lie Autonomous District Council within bracket Village Council, 4th Amendment Act 2023 submits that under the amended provision, the Executive Committee may appoint a commission consisting of one, not more than 3 persons from amongst the officers of the District Council to inquire into the affairs of the Village Council if it considers reasonable on a complaint in writing that the Village Council is too inefficient or is unable to carry on the village administration, or is acting in manner prejudicial to the interests of the state or the district council, or is known to have been indulged in corrupt practices in the matter of village administration, and out of the aforesaid three grounds, none of them have been reflected in the impugned notifications dated 15th of May 2026 and also 18th of May 2026, and as such, the said notifications are illegal and the same requires interference of this court. However, learned counsel for the respondent number 1 to 3, referring to page number 78 and what is the other complaint?
Page numbers
One is 79, one is 78.
74 is another complaint. Which translation?
74 is the so-called notice. 73 is the complaint. Referring to page number 73.
72 is the original.
73 is the English version.
Yes,
Page
Lordship.
number 73 and also 78 submits that complaint has been received in respect from the President Young Lai Association, Nagan Pukai branch, and also from some other members and in respect of the same, the inquiry commission was appointed and pending inquiry the village council was suspended, and that the same was done in accordance with law, and as such the same requires no interference of this court. The submission of learned counsel for both the parties requires further consideration. At this stage, notice be issued to the respondents returnable in 2 weeks. You served the notice by disseminate.
Do that.
However, no formal notice is required to be issued to the respondent number 1 to 3 since Mr. So-and-so entered evidence and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon rest of the respondent be taken by speed post and also by usual process within a week from today. Additionally, dusty service is also permitted. After effecting service upon the said respondent by dusty mode, the petitioner shall file an affidavit before this court. Also issue notice in respect of the interim pair of the petitioner. List the matter on. We will fix it at when? Can it be 3rd of July?
Yes, Lordship.
3rd of July?
Yes, my Yes, my lord.
Item number 2 and 3.
May it please your lordship. Lordship, I'm appearing on behalf of my senior for the respondent number 3 and 4, the MPSC, my lord. And as per the last order, we have filed our affidavit, my lord.
When?
On 2nd June, my lord.
2nd of June.
Yes, my lord.
You are for respondent number 1 and 2.
1 and 2 in item number 2, my lord, and 3 and 4 in item number 3.
No, in item number 2, you are for 1 and 2.
Yes, my lord.
Here you have not filed the affidavit.
No, my lord, we have filed.
No, there is one office note dated 18th of June 2026. It indicates that you have not filed the affidavit.
Lordship, we, as per our
On
records,
which that
Lordship,
you have filed?
yes, my lord. We have filed on the 2nd of June, my lord.
2nd of June.
Yes, my lord. And last order was at 1st June, my lord. So we have filed the next day.
Whether the affidavit filed in WPC number 73, item number 3, will serve the purpose in the item number 2 also.
My lord, as we have filed a separate affidavit, my lord, for item number 2.
No, madam, you see this record. There is no indication that you have filed affidavit in this matter. So this. Madam, you are the petitioner in item number 3 also.
Yes, my lord.
Whether you have received the affidavit in opposition filed by the respondent number 1 and 2 in item number 2,
Lordship, I'm not very sure of that.
you are not sure.
Yes, sir, my lord.
Petition in the year 2024.
Yes, my lord. For the for item number 2, my lord, we have filed on 2024, and for this item number 2, we have just filed on the 2nd of June, my lord.
Okay. So, are you ready to argue the matter today?
Not today, my lord. If this may kindly be taken up after 2 weeks.
After 2 weeks.
Yes.
Heard, miss, your name please?
Lelrin Amit Sakla.
Learned counsel for the petitioner. And also heard, madam?
Daphne Shoitlongi on behalf of my senior, my lord.
Learned counsel appearing on behalf of Mr.
Jesse Lanunsanga, my lord.
Learned counsel for the respondent number 1 and 2.
Yes, my lord. And 3
In
and
item number 2 and 3 and 4 in item number 3.
yes, my lord.
Item number 3. The learned counsel for the respondent submits that in item number 3, she has filed affidavit in opposition on 2nd of June 2026. The learned counsel for the petitioner submits that both these matters may be listed for admission hearing after 2 weeks.
Yes, my lord.
Where allowed, recess and raise the matter immediately after reopening of the petition.
Apply.
Item number 4.
May I please, Your Lordship? My Lord, even though this item is fixed for today, it may be taken up this Thursday, my Lord.
Thursday?
Yes, pleadings are complete now and an attempt for disposal may be made.
Okay. Heard, Mr. Your name, please?
Lal biak no namte, my Lord.
Learned counsel for the petitioner. And also heard anybody for the respondent? Respondent number 1. Respondent number 1. The learned counsel for the petitioner submits that this matter may be listed on coming Thursday, and on that day an endeavor may be made to finally hear and dispose of the same. Accordingly, it is provided that rest is list the matter on Thursday as
Obliged,
fixed
Your
item.
Item number 5.
Yes, my lord. Notice to respondent number 2 is still awaited, and if I may be granted another 2 weeks' time to assure that the notice has been served.
Where the respondent number 2 is residing?
Darlon, and it has to be sent to Darlon police station.
In Aizal district?
No, Champhai district.
Sampai.
Yes, Your Lordship.
Sampai is not far away. It is just 2.5 hours journey from here.
Exactly.
So why you were taking so much time? The accused is behind the bar. Part Miss Ruth Fairley, learned amicus curiae for the appellant, and also heard Miss learned APP
APP.
for the state. The learned APP submits that she may be granted further 2 weeks time to receive the instruction in respect of service of notice upon respondent number 2. Pair allowed list the matter immediately after reopening of the vacation.
Deeply obliged.
Whether paperwork was prepared here?
Paper book. I have received a paper book. Yes, Your Lordship. We have received the paper
Received?
book. Yes.
Okay. List the matter. We will fix it that on 13th of July.
Yes, Your Lordship.
13th of July.
Item number 6. Lordship, in this matter, affidavit is awaited for respondent number 1 to 4, Your Lordship.
Yes, Your Lordship. I'm presenting the state respondent, that is respondent number 1 and 2.
1 and
1 and 2. And I'm seeking another 2 weeks' time to file my affidavit, Your Lordship.
Similar prayer for respondent number 4.
My Lord, I'm for respondent number 3.
respondent heard Mr. Silo, learned counsel for the petitioner. Madam for respondent number 1 and
1 and 2.
1 and 2, and Mr. Respondent number 3, your name please. And Madam for respondent number 4. The learned counsel for the, you have filed your affidavit? 5 and 6. And Mr. So-and-so, learned counsel for the respondent number 5 and 6. The learned counsel for the respondent number 1, 2, 3, and 4 submits that they may be granted 2 weeks time to file counter affidavit. Pair allowed. Since when the matter is pending?
My Lord, it's pending
2025.
since August 29th August 2025.
Considering the fact that notice was issued to the respondent on 29th of August 2025, last opportunity is granted to the respondent number 1, 2, 3, and 4 to file their counter affidavit. List after 2 weeks.
Item number 7.
May I please, Your Lordship?
Yes,
My Lord, Your Lordship had heard this matter last week.
yes, yes.
And I have brought some authorities rendered by the Honorable Supreme Court, 3 judgments, which says that post-retirement, fresh disciplinary action cannot be taken upon the pensioner, my Lord. Provided if only while in service, if the disciplinary action was initiated, that can be continued even after post-retirement. But, my Lord, coming to the present case, my Lord, if I may take a lordship to rule number 6 of the Staff Service Amendment Rules 2020. Rule number 6. Rule number 6. Page number 6. It's in page number 6. Rule number 6.
Page number?
Page number 6. Rule number 6. Grades and scales of pay.
Yes.
My Lord, here under rule number 6, the various categories of employees under the respondent authorities were defined, which consist of officers, clerical, and subordinate. So what I mean to say here is that, my Lord, after I was retired on superannuation on 30
No, that's all right, but Mr. Alte, you see, you have been reappointed.
That is what I mean to say, my Lord. For re-employment or extension, my Lord, that extension or whatever appointment has to come under the purview of these rules. But my re-employment was as a consultant only, my Lord, not come under any of the categories of these employees defined under this Rule 6, my Lord. And Rule 34 provides yes, under Rule 6, my Lord, there is age of superannuation as 60 years. And if I may take a lordship to my re-employment order, which is in affidavit filed by the respondents, my Lord. Page number 13, 1-3. Affidavit on opposition filed by the respondents.
Page number?
Page number 13.
Yes.
This is order dated 7th August 2021. In pursuance to the resolution number so and so of the Board of Directors meeting held on 23/7/2021, and in the interest of the Mizoram Cooperative Apex Bank Limited and its affairs, the petitioner is hereby appointed as PDC consultant on contract basis as per the terms and conditions mentioned below. Here, my Lord, this PDC consultant PDC stands for X Development Cell, which P stands for Primary Agricultural Credit Cooperative Society. So under the respondent authority, my Lord, they have initiated some project and a scheme under the agriculture project, my Lord. And herein I was appointed as consultant. The main job rendered by the petitioner was giving a training to the beneficiaries. And as can be seen from the terms and conditions, my Lord, they were giving specific terms and conditions, which implies that I was not bound under the prevailing service rules of 2020. And this PDC consultant is nowhere to be found in the service rules in the name and post of the staff employees under the staff service rules, my Lord. So I cannot be regarded as an employee I cannot be termed.
You are not, your submission is that you are not governed by the service rule.
Yes, my lord. And there is no any other regulation for re-employed person or post-retirement employee.
Okay.
If I may place the authority of in the case of UCO Bank versus Prabhakar Sadasiv Parvade, reported in 2018, volume 14, SEC, page 98. Para 9. Although the regulations, the rules were different, my lord, but the ratio laid down by the Honorable Supreme Court in this case. Para 9, my lord. I read from Para 9.
Yes.
A reading of the plain language of Regulation 4 of the Discipline and Appeal Regulations and Regulation number such and such of the 1979 regulation makes it clear that any of the penalties, whether major or minor, can be imposed only on a serving officer or employee of the bank. This necessarily implies that none of the penalties specified in Rule 4 of the Discipline and Appeal Regulations can be imposed on an officer or employee after his retirement from service, though in terms of regulations such and such, the disciplinary proceedings initiated against an officer employee before his retirement can be continued and final order is passed, and further that such officer employee is not entitled to retirement benefits till the conclusion of the disciplinary proceedings and passing of final order. The only exception to this is that the officer is entitled to receive his own contribution to CPF. However, there is nothing in the language of these regulations from which it can be inferred that the disciplinary authority has the power to impose a substantive punishment on retired officer employee. This becomes more explicit from a conjoint reading of the regulation of the pension regulation, which empowers the competent authority to withhold or withdraw a pension or a part thereof, and order recovery from pension of the whole or part of any pecuniary loss caused to the bank, if in departmental or judicial proceedings the petitioner is found guilty of grave misconduct or negligence or criminal breach of trust or forgery or acts done fraudulently during the period of his service. Second proviso to regulation contains a fiction and lays down that if the departmental proceedings are instituted while the employee was in service, the same shall be deemed to be proceedings under the regulation and continued and concluded as if the employee had continued in service. The third proviso imposes a bar on the initiation of the departmental or judicial proceedings against an employee after his retirement in respect of an event which took place more than 4 years before such institution. The sum and substance of this regulation is that even though a departmental inquiry instituted against an officer employee before his retirement can continue even if after his retirement, none of the substantive penalties specified in regulation, which include dismissal from service, can be imposed on an officer after his retirement on attaining the age of superannuation. Therefore, we have no hesitation to hold that order dated so-and-so passed by the disciplinary authority dismissing the respondent from service who had superannuated on 93 was ex facie illegal and without jurisdiction, and the High Court did not commit any error by setting aside the same. We may also observe that master and servant relationship between the respondent and the employer bank had come to an end for all practical purpose on 1993, that is the date of superannuation. The departmental inquiry initiated against the respondent before his retirement could be continued for limited purpose for determining whether or not he is entitled for full pension and benefits and gratuity. My Lord, in the light of this, my Lord, there is a recent judgment of the Honorable Apex Court in the case of Virender Pal Singh versus Punjab and Sindh Bank. Virender Pal Singh versus Punjab.
Yes.
My lord, dear, copy of the judgment, mine is page 33 pages. I just want to know whether we're on the same page of the same judgment or not. This is reported in 2026 SEC.
Yes,
online.
yes.
Virender Pal Singh versus Punjab and Sindh Bank.
Which paragraph you are relying upon?
Yes, my lord. My lord, para 13, 1-3. They have sorted out the 2 points for consideration in this case. Para 13. On consideration of the rival submissions, in our view, following issues arise for our determination. Whether post-retirement of the appellant, punishment of reduction of 3 stage in the scale of pay as imposed by the respondent was permissible under the extant service regulations, or action under the pension regulations was the only way forward. Number 2, whether we are not concerned with number 2, my lord, I'll skip this. And on para 4, they are first addressing the question of issue number 2. And the first issue was dealt with from para 23. Para 23.
Yes.
Now, we shall address issue number 1, whether post-retirement, the punishment as imposed upon the appellant is permissible in law. Here, my lord, they are relying on the first judgment which I have produced.
Yes.
In para 27, 28, they are reiterating the case of the first judgment which I have produced. Para 36, my lord, the conclusion.
Yes.
On a survey of the decisions cited and discussed above, in our view, what is settled is that if the extent service rules regulations permit continuance of the disciplinary proceedings initiated against an officer before he had attained the age of superannuation, those can be continued and brought to its logical conclusion even after he had attained the age of superannuation. And where pursuant to such proceedings, the ultimate penalty imposed is of dismissal, there may be no technical difficulty in its implementation, as it may result in forfeiture of pension and other retirement dues. My lord, what can be seen from these judgments is that only when the extent service rules provided as to whether that disciplinary proceedings can be initiated post-retirement and in view of the nature of the appointment of the reemployment, my lord, whether that is bound by the prevailing rules or not, that has to be looked into, my lord. In the present case, my lord, the prevailing service rules of 2020, it did not speak about the nature of my appointment, my lord. Although I was reemployed as consultant, my lord, that post and the status and designation was not provided by the rules itself, my lord. If I was reemployed or my service was extended under the said rules, my lord, it can be presumed that I was covered by these rules of 2020. And besides this, my lord, another case, in the case of State Bank of India versus Naveen Kumar Sinha. Here also, my lord, the petitioner, the respondent, writ petitioner herein, in the case of Naveen Kumar Sinha, was also retired on superannuation on 2003. Thereafter, his service was extended. The difference is that in this Naveen Kumar case, his service was extended before any retirement on superannuation. But in my case, I was already retired on superannuation, but I was re-employed on different capacity. And in this case, my lord, in the case of Naveen Kumar Sinha, para 18, 1A. Para 18.
Yes.
I will read this, my lord, by keeping in mind the fact that in the present case at hand, my lord, I was not served copy of the memo of charge, no charge sheet. I was only served a show cause notice. There is no serving of formal memorandum of charge against the petitioner delinquent. Para 18, my lord. In Union of India versus KV Janki Karaman, this court was examining the impact of seal cover procedure on an employee due for promotion, increment, etc. In that case, the employees were eligible for promotion, but because of pending disciplinary proceeding, were subjected to seal cover procedure. It was in that context that this court considered, amongst other, the question as to what is the date from which it can be said that a disciplinary proceeding is pending against an employee. After due analysis, this court held that it is only when a charge memo is issued to the employee that it can say a departmental disciplinary proceeding is initiated against the employee. Now, my lord, para 19, I'll skip some portion, my lord. Para 19, my lord, on the same page of last sentence, it starts with reiterating the view taken. Have you got it, my lord? Reiterating the view taken in KV Jani Karaman Supra. This court held that the departmental proceeding is not initiated merely by issuance of so-called notice. It is initiated only when a charge sheet is issued. In the facts of that case, since the disciplinary proceeding was initiated after the age of superannuation, the charge sheet, inquiry report, and the order of punishment were held to be illegal and without jurisdiction by this court, and those were set aside. Consequently, all retirement benefits due to the respondent was directed to be paid. Similarly, in Coal India Limited versus Saroj Kumar Misra, this court again reiterated that the legal position that a departmental proceeding is ordinarily said to be initiated only when a charge sheet is issued. Para 30, my lord, 30. Para 30, 30. Disciplinary proceeding against the respondent was not initiated on 18/8/2009. When the first notice to show cause was issued, but was initiated only on 18/3/2011, when the disciplinary authority issued the charge memo to the respondent. As is held by this court on more than one occasion, a subsisting disciplinary proceeding, that is, one initiated before superannuation of the delinquent officer, may be continued post superannuation by creating a legal fiction of continuance of service of the delinquent officer for the purpose of conclusion of the disciplinary proceeding, in this case as per the service rules and so. But no disciplinary proceeding can be initiated after the delinquent employee or officer retires from service on attaining the age of superannuation or after the extended period of service. Besides this judgment, my lord, in the present case, when the so-called notice was issued to me, the provision of the staff service rules of 1995, the old rules, was invoked, my lord. The existing rules is 2020, which repealed the 1995 rules as well as the amended thereafter. But the respondent authority have invoked the old pre-existing rules, my lord.
No, you see, come to the definition of Rule 5, Clause F. Employee means any person in whose, no, in the whole time employment of the bank, whether permanent, officiating, temporary, employed under a contract. So in view of this definition, whether you are not an employee of the said bank.
No, my lord, because this Rule 5F cannot be read in isolation, my lord. It has to be read the rules in its entirety, my lord, because Rule 6 provided the list of categories of employees under the respondent's authorities, my lord. And no doubt I was initially appointed as clerical staff and then promoted from time to time, and ultimately at the time of my superannuation I was retired as AGM. And post-retirement, my lord, when my re-employment order was given, my lord, none of these list of categories of the employees under the bank, I was not under this list of categories of employees, my lord. This PDC consultant, as I have pointed out earlier, is only for serving as an advisor or trainer.
No, even then, your employment is under a contract.
It's on contract for a contractual period of 2 years, my lord.
So would you not come under this definition of employee?
No, my lord. My humble submission is that, my lord, in the case of re-employment or extension of service, my lord, the designation status has to be defined, my lord. And in order to come under the scope and ambit of these rules of 2020, my lord, that should come under one of the category of the employee, my lord.
Do you have any decision on this point to support your contention?
Yes, my lord. I'll read more in the Virender Pal Singh case, my lord.
Which one?
Virender Pal Singh. Virender Pal Singh.
In which paragraph it is stated?
Under para 28, my lord.
28.
Yes, my lord.
Yes.
This is reiteration of Prabhakar case, my lord, that I have pointed out earlier. On the second last paragraph, or under para 28, second last paragraph,
Para?
internal para 9. The paragraph starts from after considering the aforesaid regulation,
Para 9.
Para 9, my lord.
Yes.
On the middle of the line, it's underlined. However, there is nothing in the language of these regulations from which it can be inferred that the disciplinary authority has the power to impose a substantive punishment on retired officer employee.
Which paragraph you were reading?
Under para 28, my lord.
28.
Yes, my lord. There is reproduction of the rules therein.
Rule 9.
Rule 9.
Yes.
A reading of plain language of the regulation of the discipline and appeal regulations. Have you got it, my lord?
From which part you were reading?
From internal para 9, a reading of the plain language of regulation 4. On top of that, it starts with, after considering the aforesaid regulations, this court held as under. Have you got it, my lord?
Before the underline
Yes, my lord.
sentences.
Yes, my lord. The line starts with a reading of the plain language of regulation 4 of the discipline and appeal regulations and regulation 2020 of the 1979 regulation. Makes it clear that any of the penalties, whether major or minor, can be imposed only on a serving officer employee of the bank. This necessarily implies that none of the penalties specified in regulation of the discipline and appeal regulations can be imposed on an officer after his retirement from service. Though in terms of regulation of the 1979 regulations, the disciplinary proceedings initiated against an officer employee before his retirement can be continued and final order is passed, and further that such officer employee is not entitled to retirement benefits till the conclusion of disciplinary proceedings and passing of final order. The only exception to this is that the officer is entitled to receive his own contribution to CPF. However, there is nothing in the language of this regulation from which it can be inferred that the disciplinary authority has the power to impose a substantive punishment on retired officer employee. Coming to the present service rules of 2020, my lord, there is no language in the rules providing that disciplinary authority has the power to impose substantive punishment on retired officer employee or re-employed person.
Okay. Okay. Yes, any reply?
Please, Your Lordship. Since Your Lordship has also made a query to my learned friend with regard to Rule 5F, the definition of employee, my Lord. My learned friend has proposed that the petitioner could not be regarded as employee since Rule 6 of the 2020 rules does not state his post, which is a consultant. Here, if we see Rule 6, it is only a substantive post. Now, if we look at Rule 5F, it is clear as a day that he comes within the definition of employee. And we accept the fact that there is no disciplinary proceedings drawn against the petitioner. However, he was issued a show cause notice in compliance of natural justice principle, and he had given an answer to the show cause notice. Further, he had also submitted an appeal by invoking the 2020 rules, and his appeal was rejected. Now, the action of the petitioner is that he is stopped by his action manner. Today, he says that this cannot be applied. Yesterday, he says that it can be applied. So he cannot appropriate and reprobate in this case. Had he not replied to the show cause notice, or had he not filed an appeal before the executive committee, my lord, to our understanding, he would have a case, but his appeal was rejected. And if we look at the prayer of my learned friend, the respondent, my lord, he sought to challenge the recovery which was already made. But as I have submitted earlier in the last court date, writ code cannot be used for recovery of money, my lord. So if your lordship may kindly come to the prayer portion of my learned friend, the petitioner, that is at page 18.
No.
Okay.
We are testing the order of imposing the punishment.
Yes, ma'am.
Punishment means the recovery.
Yes, recovery. Now, as I have submitted earlier, we need not draw a disciplinary proceedings as per Rule 101, my lord. I'll just mention specifically the provision, my lord. Since my learned friend has relied upon the 2020 rules, I believe your lordship has the book.
Yes.
101 sub clause 1 sub clause 2.
101.
Yes, my lord. Rule 101. The relevant portion is sub clause 1, sub clause 2. It starts from there. And sub clause 2, further sub clause 2, my lord. Your lordship may kindly come at page 83 and 84 of the book.
Yes.
So it's mentioned there, my lord. So this is a minor penalty which was imposed upon the present petitioner. This is not a major penalty which was imposed upon him. So my learned friend cannot take the benefit that he was not given a chance to appoint counsel for representing his case, since no disciplinary proceeding was initiated against him. It was only in compliance of the natural justice principle that we had issued a show cause notice, that he had replied to the show cause notice, and he had even filed an appeal stating his case, which was ultimately rejected, my lord. Now, in this case, my lord, as your lordship has already seen that he had failed to comply Rule 84. Your lordship may kindly come to Rule 84 of the SSR 2020. Page 76, my lord.
Yes.
Rule 84 sub clause 2. Rule 84 sub clause 2, with your lordship permission, I'll read this. Its employees shall abide by these rules, and amendment, addition, or alteration thereto made from time to time, and shall observe, comply with, and obey all orders and direction which may from time to time be issued to him or her in pursuance thereto by an officer or officers to whom powers are delegated in this behalf or under whose jurisdiction superintendence or control may from time to time being placed. And Rule 84 subclause 3 is the obligation to maintain secrecy, and subclause 4 is to promote the bank's interest. Since the petitioner had issued loan against the FDR account of the bank holder without his permission, so he had violated this Rule 54.3 subclause 4, subclause 5 as well, and therefore, in the opinion of the bank, they have imposed a penalty under Rule 100C. So there is no illegality in the.
One question is, during the period of his contract, he has not committed any illegality. What he had committed is during the period of his employment in the regular employment in the bank, under the bank.
Yes, Malo.
So, can you now impose punishment upon him, and by way of imposing punishment, you can recover it from his pensionary benefits?
Yes, that is correct in the sense that your lordship has rightly pointed out that he was retired as AGM, that is substantive post under the bank on 30/4/2021.
Yes.
Now he was re-employed with effect from 7/8/2021.
No, not re-employed, contractual
On,
employed.
yes, re-employed as contract. On 7/8/2021 up to 10/8/2023. The issue which was not raised or which did not come to the knowledge of the bank is that since no complaint was received prior to 9/11/2021, the bank could not initiate any action since this account holder submitted complaint only on 9/11/2021, and it was only due to his complaint that we came to know that there was discrepancies or fraud committed by the petitioner hearing. With regard to the procedural left, my lord, or the judgment of the Honorable Supreme Court, which says that no disciplinary proceedings can be drawn against the retired official, we have to see with the rules, my lord. What my other friend is relying upon the Honorable Supreme Court judgment, which I have not read, maybe in context of other rules or regulations. Now here we have to decide the case in the context of this SSR, Staff Service Rules 2020. In the case provided by my other friend, there may be no Rule 5F which says that a contract
No,
employs
maybe
also an employee.
rules may be different, but the proposition of law laid down in those cases may be applied in the present case also. That is his
Yeah,
submission.
that is his case, and
Yes.
I accept that also. But we have to look with this case also, my lord.
Yes.
My lord. So it is my prayer that all the judgment which my other friend has furnished may also be looked into the context of this particular case, vis-a-vis the case which was relied upon by, which was decided by the Supreme Court in that case. So in our case, and since my other friend prayer is twofold, he has asked the court to give a direction to the bank to return the money, which I have placed the Honorable Supreme Court judgment that it cannot be done by way of this writ. And
No, no, not necessary.
yes, my lord,
If we set aside the impugn order,
my lord.
then everything gone. You are bound to return the money to him.
If he has to go to other remedy, my lord.
Pardon?
He has to go to the other remedy.
No, that
No,
is a
that-
different aspect.
that
but
is my understanding.
if we set aside the impugn order,
Yes, my lord.
then you are bound to return the money.
If we look at the impugn order, my lord, what the impugn order is says like this.
And another aspect is there. So the word pay from the pay is there in the rule. But you have transferred his bank account from Saiha to
Dorpui.
Dorpui branch. There I'm maintaining two saving banks account, wherein my pension was earlier credited in my Dorpui branch account, my lord. They have made overdrawn withdrawal from that, which is beyond their jurisdiction, exceeding their jurisdiction, my lord. And
but you see the from the word pension is not there, pay is there.
Page.
Can we interpret the word pay in such a manner so as to incorporate the word pension also or fixed deposit also?
According to us, it also includes pension. But whether this my friend can submit any other citation or authority, maybe he is not in that position today. I leave it to the wisdom of your lordship with regard to that. But we submit that pay includes the pension which he had received from the bank. Any emoluments, any fund which he had received from the bank. No. So my submission in sum and substance, I'll conclude my submission, my lord. Since the petitioner had chosen to reply to the so-called notice, and
Now he cannot
now
reprobate.
yes, he cannot reprobate. He cannot say that we are not following the rules because we are following the fundamental principles of law that we have to comply with the natural justice principle. Because he had not denied what he had done.
Your Lordship, may kindly
Okay,
see.
now, how much amount of money you have recovered from him till the interim order passed by this court?
I have the latest statement. From the statement, bank statement, my
Whether
lord,
the recovery is completed according to you?
No, not yet completed, my lord.
How much amount remains?
Now, I'll just look at the show cause notice, my lord.
in the statement which I have furnished, my lord, according to the show cause notice, the liability of the petitioner is about rupees 17 lakhs 64,000. And my lord, if you kindly look at the statement dated 30/4/2025, there's a deduction of 16 lakhs 76,737, as well as on top of that, my lord, 1,21,200. This was also deducted, my lord. So I have made the addition, the calculation in the handwritten. They have deducted 17 lakhs 97,937, and my monthly pension is rupees 35,000, and they have already made me to repay the overdrawn withdrawal for the past 9 months, which amounts to rupees 3 lakhs 15,000. Whatever amount, whatever money is in my account, my lord, they have auto debit to that for repayment of the overdrawn withdrawal.
No. So what is the amount remains to be recovered?
87,990, my lord.
But the entire amount of his pension you cannot recover.
My lord, as per the order of this court, we stop debiting
that's
this,
all right.
my lord.
But earlier you have recovered entire amount of pension from his pension account. That is not permissible.
Yeah, my lord. Yes, my lord.
Okay. We'll pass the order.
Obliged.
Heard Mr. Ralte, Lord Appointed for the Then also heard Mr. So-and-so, learned counsel for the respondent, argument concluded, judgment reserved.
My lord, if I may be allowed to point out only one point.
Yes.
In my writ petition, my lord, my learned friend has keep on submitting regarding appropriate, reprobate on the rules which was enforced, my lord. The first so-called notice and the proceeding was drawn by relying on the pre-existing old rules, that is 1995. And upon imposing the impugned penalty order, my lord, I have no other remedy. Had first approached the appellate authority, which is the same under the old rules and the new rules. The appellate authority is the chairman of the bank limited. And my lord, page number 40 of the writ petition, my lord. Kindly see page number 40 of the writ petition. This is my statutory appeal against the impugned order, my lord. And the continuation of that state appeal, my lord, if I may take your lordship to page number 52. Running page number 52. Grounds number 9. Where I have specifically pleaded that for that the disciplinary authority failed to notice that they are relying upon the Staff Service Amended Rules 1995, whereas the same was already repealed by the Staff Service Rules 2020. Therefore, the entire departmental proceeding stands vitiated. So there is no question of appropriate or reprobate doctrine in this case, my lord. They are applying the wrong rules, and by the wrong rules, my lord, they have imposed the impute penalty. And I have specifically pleaded in my appeal that this was already repealed law rules, and it should, the entire proceeding stands vitiated, my lord. So there is no question of the doctrine of appropriate or reprobate.
My lord,
And in the present case, my lord, the alleged misconduct was occurred 2004 and 2005. And there was always annual audit internal and from outside. During the relevant time, there was no any findings of the alleged misconduct. More or less, my lord, I have rendered my entire service to the best of my ability without any blemish record during my entire career, my lord. Now, the manner in which they have acted by the respondent authority, my lord, they will serving me so cause notice on 2024. I had replied, and they have relied on the sole testimony of the complaint, the alleged complainant, my lord. But my replication was that against the fixed deposit of that same person, my lord, that person had lent it to some other person. It's between their case. Neither the petitioner nor the bank has no responsibility.
No, the fact is that no regular departmental proceeding was drawn up against you.
Yes, ma'am.
So, had it been there, then the position would have been quite different. Okay.
my lord, if I may not be tedious to you, also, since we have taken a long time, since my other friend has pointed out that 1995 rules was supposedly used, but in this case, this 1995, which the rules mentioned in the so-called notice, is very material to Rule 2020, that is, obligation to maintain secrecy. It was there in the 2020 rules. Now, to assist the Honorable Court, this 2024 has come later on, but the relevant portion, the relevant rules would be 2020, and now whether this 2024 would come or not is also another question. But the moot question is that whether disciplinary proceeding has to be drawn or whether the petitioner can be punished after his retirement. That is what I understand, madam. So I'll place this 2024 also, madam.
Okay. Now you are now there remains to be recovered is sum of rupees 87,000.
That will be baseless, my lord, because from the statement which I have given you, they have make overdrawn withdrawal more than 70 lakhs from my account.
If I also may kindly,
I was made to repay it only rupees about 3 lakhs, my lord. That means approximately 13-14 lakhs will continue to be recovered from my pay, from my pension.
Your Lordship may kindly record this. The balance is rupees 17,64,727.
17 lakhs.
64,727. Now, I have placed a letter which was issued
Yes.
by the
Yes.
DGM. Here it says that the bank has debited a sum of rupees 17 lakhs 11,737.
Debited means they have made overdrawn withdrawal in my account. And whenever my pension came, that was auto-debited for repayment of the overdrawn withdrawal.
I'll just do the calculation, my lords.
For the past 9 months, they have diverted my pension, which amounts to total 3,15,000.
Now, the remaining amount which I have submitted earlier is not correct. This is the correct. 52,990, my lord. 52,990, according to us. I think which my learned friend would again dispute that.
My lord, when the bank themselves admitted that they have deducted more than 17 lakhs, my lord, and they have made recovery from my pay only for 9 months, which amounts to 3 lakhs. Obviously, that will be more than 14 lakhs, my lord, that remaining, that they are yet to continue.
Okay.
Obliged, my lord.
Argument concluded, judgment reserved.
Did they oblige?
Item number 9.
Sentence filed with assembly.
I seek your lordship's indulgence in making a mention regarding, on behalf of the senior counsel, lordship. There has been some personal difficulties there. His cousin died yesterday, lordship. He has to attend a funeral today, so if this matter may come up tomorrow.
But madam, you see, this is second appeal.
Yes, lordship.
In second appeal, in the memorandum of appeal itself, you have to suggest the substantial question of law as provided under subsection 3 to section 100 CPC.
Lordship.
Have you suggested any substantial question of law in this memo of appeal?
I believe, my lord, there's no suggestion, lordship. I believe there's no suggestion as such.
Not suggested. But there is a requirement of subsection 3 to section 100 CPC. You go through the same. And besides, there is also one decision of the Supreme Court, which requires that the substantial question of law has to be mentioned in the memo of appeal itself.
That we will have to have.
And madam,
look at it,
another
my lord.
thing you say, in the trial court you are not a party.
Not a party in the trial court. Lordship,
Then how the first appellate court would appreciate your case?
It was dismissed, my lord.
It was
with-
dismissed.
Yeah, with appeal to with liberty to for the appellant to file a fresh suit before the civil judge. However, the appellant is not satisfied with that order, so hence the second appeal is.
No, but the question is that except the memo of appeal, you have nothing to substantiate your case.
Lordship, that I have to clarify with my
First
senior.
appellate court has observed that it is undeniable that it would not be within the scope of Order 41, Rule 27 for the appellate court to take evidence in respect of those averment made before the first appellate court.
Lord, that I have
Better
to.
you could have preferred one review petition before the trial court. Though you are not a party before the trial court, this review petition is maintainable. There are several decisions of Supreme Court. Anyway, heard Miss so-and-so, learned counsel appearing on behalf of Mr. So-and-so, learned conducting counsel for the appellant, submits that the conducting counsel has some personal difficulties today and she pays for listening the matter after
Tomorrow, my lord.
tomorrow.
Lordship.
Tomorrow there is DB perhaps. Okay, anyway. Heard Miss, your name?
Lieutenant Louis, on behalf of Mr. Bilaram Enga, counsel for the respondent number 5.
Respondent number 5 and madam for respondent number? 124. 124. List the matter tomorrow.
Obliged.
Item number 10.
Please, Your Lordship.
seek your lordship's permission to withdraw the petition with liberty to file afresh. There are certain subsequent developments here. If your lordship will see in the writ petition, at page 2 of the writ petition, the respondent 5, 6, and 7 are the Defense Secretary, Government of India, the Director General Defense Estate, and Defense Estate Officer. Your Worship, when the suit was filed, the land belonging to the petitioner was occupied by the Defense Forces, Army. Subsequently, it changed hands. As on date, it is occupied by the Assam Rifles, who come under the Ministry of Home Affairs. And if your lordship will see the affidavit filed by the state, in the affidavit filed by the state at page 12, the rent has been paid by the Assam Rifles, which fall under the Ministry of Home Affairs. So now, I think we'll have to complete the Ministry of Home Affairs. Because early on, it was the army which had occupied the land belonging to the petitioner. Subsequently, the occupation was transferred to the Assam Rifles. So Assam Rifles falls under the Ministry of Home.
Okay.
And they have paid the rent till 2023. So now, subsequent 3 years rent is also pending. So I may be allowed to withdraw with liberty to file a fresh. I can bring the subsequent facts to the notice of this Honorable Court in a fresh petition.
Okay. Any objection?
No objection.
No objection. Heard Mr. A.R. Malhotra, learned counsel for the petitioner, and Madam learned CGC for the respondent number
5 to 7.
5 to 7, and Mr. Learned counsel for the respondent number 1 to 4. 1 to 4. Mr. Malhotra, learned counsel for the petitioner, submits that due to some subsequent developments, the petitioner is willing to withdraw this petition with a liberty to approach this court by filing appropriate petition, by pleading the Ministry of Home Affairs of Union of India as necessary party. The learned counsel for the respondent submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Orders, item number 11.
May I please, Your Lordship, my Lord. The instant appeal relates to the question of property between natural mother and biological son. Appellant is mother and the sole respondent is her son. My Lord, in this case, the sole respondent has obtained heirship certificate from the concerned court without hearing the appellant. So
there is a delay in filing this appeal.
my Lord, with that regard, I'd like to submit your this authority for your this. My Lord, and heirship certificate was issued way back in 1st December 2020, but the said issuance of the said heirship certificate was known to me on 4th September 2025. For that reason, relevant date limitation, a relevant date with regard to limitation has to be counted from 4th September 2025. Page number 3, subparagraph 6. It is seen that though notice was the limitation began to run only when the appellant had knowledge of the ex parte decree. So in the case of heirship application, no information or notice was given to the appellant by the court. So it is a cover matter with regard to question of limitation from the date of knowledge or from the date of order. But in the case, in the instant case, since the appellant was not informed about the filing of heirship certificate, or she was not supposed to.
But you were a party in the proceeding before the trial court.
No, we are not a party in the heirship case. The heirship certificate was obtained by the respondent without the knowledge of the appellant. Heirship certificate was submitted on 1st December 2020 and it was issued on the same day by the trial court.
No, that's all right. But since there is delay, why don't you file one interlocutory application under Section 5?
Yes, since we have not filed, so this authority is brought because in the instant case, no notice was.
No. This decision could have been considered in that application under Section 5.
Yes, application was filed, but the trial court said that it was not within the condonable period. But the sub-report said that it was done. Limitation has to be taken up from the date of knowledge of the order impugned.
There is no doubt about it.
So we taking the first date when the issuance of heirship certificate was issued, the instant application was filed. By taking that, the appeal was filed in time. From the date of knowledge.
Where is the impugn order?
Impugn order, page number 14. Hello, page number 13. Annex 3. May I read? 1st December 2020. This is an application for issuance of heirship certificate under Section 30, Clause 3 of the Mizo Marriage, Divorce and Inheritance of Property Act 2014, submitted by Mr. M. Hunter Namte, son of L.T. Zaman Namte, resident of Narsari Veng, Aizawl, Mizoram, in respect of LSC number 167 of 1981, located at Narsari Veng, which was left behind by his deceased father, late L.T. Zaman Namte, in favor of the applicant. The application is accompanied by copy of death certificate, copy of LSC, voter ID of the applicant, no objection letter, Muninpeg na lekha, an acknowledgement letter issued by Chairman Narsari Veng Local Council are also annexed. On careful perusal of the application and the related documents and on hearing the applicant, this court holds the opinion that the application is genuine and true. Hence, heirship certificate be issued to Mr. M. Hunter Namte, son of L.T. Zaman Namte, late resident of Narsari Veng, Aizawl, Mizoram, in respect of LSC number 167 of 1981, located at Narsari Veng, which was left behind by his deceased father, late L.T. Zaman Namte, in favor of the applicant. with the above order, the application is disposed of. Statement of the applicant was also not recorded by the court.
You see, whether separate application under section 5 is required or not, that issue has not been dealt with in this decision.
My lord, from my side, it is not necessary because
No.
I filed the appeal
No,
within 90 days from the date of knowledge of the impugned order and heirship certificate thereof.
Better you file an application.
My lord,
We will consider your pair.
my lord.
Heard Mr. Lal Ramt Luanga, learned counsel for the appellant. Pursuant to order dated 10/6/2026, Mr. Lalram Luanga, learned counsel for the appellant, has produced a decision of Honorable Supreme Court in the case of Gauhati University versus Nirmal Bhattacharya, reported in 1995 6 SCC 731, page number 731. This court has carefully gone to the said decision and also the issue of condonation of delay of nearly 5 years in preferring the present appeal. Having considered the submission of learned counsel for the appellant and also considering the given facts and circumstances on the record, this court is of the view that there is a requirement of filing a petition under section 5 of the Limitation Act for condonation of delay of nearly five years in preferring the present appeal. Accordingly, it is provided that the learned counsel for the appellant shall file an application under section 5, one interlocutory application under section 5 of the Limitation Act for condonation of the aforementioned delay. List after 1 week.
My lord, 2 weeks.
2 weeks.
Yes.
You are for the respondent.
Yes, my lord.
Mr. So-and-so, learned counsel for the respondent.
Item number 12. My lord, in this case, being a special PPCBI, my appearance may be entry in the cause title at respondent.
You are for the respondent.
Yes, my lord. Special PPCBI.
CBI.
Yes.
Your name has not been reflected in
My
the
lord.
cause list.
Yes.
Not been reflected.
No, not reflected. But last year it was reflected. But now it is not reflected.
Not reflected. None appears for the appellant on call.
Paper book is not yet served to me.
Learned counsel for the respondent CBI present. The learned counsel for the respondent CBI submits that his name has not been reflected in the cause list. Accordingly, it is provided that shall reflect the name of the learned counsel for the CBI in the cause list.
Paper book is not yet given to me also.
Pardon?
Paper book is not yet given to me.
Pardon?
Paper book. Paper book is not yet given to me by the registry.
Paper book. Paperwork was prepared.
Yes, already. When the cost is paid by the council.
Okay. On payment of cost by the learned counsel for the CBI, Registrar shall furnish a copy of the paperwork to him.
My lord, petitioner appellants are to bond the cost of the preparation of paper book. After
So
finishing
you
that
will
one,
entitle to free of cost.
yes.
Okay. Registrar shall furnish a copy of paperwork to the learned counsel for the CBI, free of cost.
Much obliged.
Item 13. Please, Your Worship. As per the office noting, the paper book is ready. We have to pay the cost of the paper book, Your Worship. 1
Okay.
week's time may be given.
Pardon?
1 week's time may be given for making payment of the
Mr.
paper book cost.
Palutra, learned counsel for the appellant. And Madam for the respondent number?
Number 2, number 1.
Respondent number 1. Respondent number 1. Office note dated 18/6/2026 indicates that paper book has already been prepared. Mr. Balutra, learned counsel for the appellant, submits that he may be granted 1 week time to obtain the paper book on payment of necessary fees. Pair allowed, Registrar shall list the matter after a week. We should, Mr. Balutra, it should be fixed for hearing
No, it will be fixed for orders, then it will be fixed for hearing.
orders.
Yes.
Okay.
Item 14. In item 14, Lordship, I have filed my affidavit in reply this morning, my Lord. So if it may kindly be listed for admission hearing next week, my Lord.
Admission hearing.
My Lord, since pleadings are now completed.
Heard Mr. So-and-so, learned counsel for the petitioner, and Madam for the respondent number? State respondent.
State
Yes,
respondent,
state
my Lord.
State
respondent,
respondent. The learned counsel for the petitioner submits that he has filed the additional rejoinder affidavit today,
This morning, my Lord.
today morning. And he prays for listing the matter after a week.
No, my Lord, if I can have a date next week, my Lord.
When?
Monday, my Lord.
Next Monday.
20,
Prays for listing the matter on next Monday,
29,
29th.
Monday.
Pair allowed, Registrar shall list the matter on 29th.
Item 15.
My lords, I have taken steps upon the respondent number 2 through the office of the learned additional PP. Respondent number 2 is the informant.
So you have,
I have received the information that they could locate the respondent number 2.
could not be located.
Yes, sir.
Whether the address is correct.
It's as per the FIR, my lord, yes. Phone number is also there.
It is stated that they were nowhere to be found in the said address.
Okay, then you obtain instruction regarding the address of the informant. heard Mr.
Sitlan Thiang.
Learned counsel for the appellant, and also heard Madam so learned additional PP for the state respondent.
Number one.
The learned additional PP has produced one report from the officer in charge of Bhairengti police station.
In that regard, my lord, I believe the respondent number 2 is a resident of Thenzol, Sersip district, but the letter was sent by the Bhairengti police station. So I think that will not be the correct concerned police station, my lord. It's Sersip is another district. Bhairengti is in Kolasip district, but the Thenzol, where the respondent number 2 resides, is under the jurisdiction of Thenzol police station.
I was asking you that whether you have correctly taken step upon respondent number 2.
Yes, my lord.
Is the copy of the notice available with you?
I had taken in my memo of appeal, my lord.
Pardon?
Page number 2, just after the impugned judgment and order. Page 2. The precise address along with the phone number is there, my lord. Page number 2 of my appeal memo.
Then why the notice was sent to the Bhairengti police station?
That is my point, my lord. Because if my lords will see page 14, 1-4, annexure 1. This is the FIR submitted by the respondent number 2. I've taken the address from here, my lord. So what I was saying is that the notice have been wrongly gone to the other police station, not the jurisdictional police station, my lord.
No, the occurrence took place under the jurisdiction of Bhairengti police station.
Correct, my lord.
But the informant hails from Thenzol.
Thenzol, yes. So I believe notice was sent to the Bhairengti police
Your Lordship,
station.
in that regard, notice was sent to the concerned police station. So if notice again may be sent to the residents, if you have to send to the residents, it has to be the different police station, not to the concerned police station in the present case. In the present case, the concerned IO is from Bhairengti.
I believe it has
So
to be.
if it is sent through the Bhairengti also, they can trace to the Thenzol as
Yes,
as
they
well.
can forward it to the
Yes,
Thenzol.
yes, my
They
lord.
have forwarded, so there is no discrepancies in sending there.
Maybe, but you instruct them to get it served to the officer in charge of Thenzol police station.
I think that can be done, my lord, yes.
Yes. So you have to take fresh step.
Steps was taken to the office of the London Regional PP, my lord. Because since it's a POXO matter, my lord.
No, that's
was-
all right.
Yes.
You have to take fresh step again.
If
Because
required, I can take my lord,
earlier,
yes.
whether you have received back the earlier summon or earlier notice.
That is the notice, the
In your
return
office?
notice, yes. That is from the Bhairengti
You
police
forward
station.
it to the officer in charge,
Yes.
Bhairengti police station,
Mhm.
to get it served to the officer in charge of Thenzol police station.
Yes, Your Lordship.
What is the last word? And on the basis of the said reports, he has submitted that notice could not be served upon the respondent number 2. Respondent number 2. The learned counsel for the appellant, referring to the FIR, which is enclosed with a memo of appeal at page number
14.
Page number 14, submits that, in fact, the respondent number 2 hails from Tanjol, Mizoram, and as such, the notice ought to have been sent to the ought to have been served to the officer in charge of Tanjol police station. The learned additional PP is accordingly directed to instruct the officer in charge of Bhairengti police station to get the notice upon respondent number 2 served through the officer in charge of Tanjol police station. The learned additional PP is further directed to produce the report of service report before this court immediately after reopening of the vacation. Place the matter on 13th of July.
My lords, in the meantime, the trial court records have arrived, my lord, so paperwork may
Okay.
be required.
The office note dated 25/5/2026 indicates that the scanned copy of the TCR has been received. Accordingly, registry is directed to prepare the paper book. Further, it appears that at the time of hearing, it is also to be noted here that at the time of hearing, the original TCR will be required, and accordingly, the registry is directed to requisition the original record from the learned trial court. Forthwith, list the matter on 13th of July.
Paper has to be prepared. Time is little time will be required.
Pardon?
Little time will be required for preparation of paper. So maybe
On that day?
yes, maybe a little time.
The matter on 20th July. 20.
Oblige.
Supplementary request, please. 16 and 17.
May it please, Your Lordship. My Lord, in this case, there is a slight delay of 59 days in filing the connected first appeal.
Okay.
It's only for issuing notice, Your Lordship.
Heard, Mr. Lal Fakawama, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for continuation of delay of 59 days in preferring appeal against the order dated 21st of January 2026, passed in CMA number 35 of 2025, and also the subsequent order dated 1/6/2026, passed in CMA number 68 of 2026, arising out of civil suit number 7 of 2024. Let notice be issued to the opposite party, returnable in 4 weeks.
Well, there's some urgency in this case. If it can be come up again next Friday if possible, because if with Your Lordship's permission, we would like to take steps by way of Dusty as well.
Friday.
Next Friday.
Next Friday is holiday. Monday then.
No, my lord. Next Friday would be 3rd. 3rd of July.
3rd of July.
Yes, my lord.
3rd of July.
Yes.
Returnable on 3rd of July. Step be taken by speed post and also by usual process within a week from today. The learned counsel for the applicant also submits that the applicant may be permitted to effect service upon the respondent by disseminate as there is some urgency.
My lord, only respondent number 1, 5 and 6. 2, 3, 4 we've already furnished.
Upon respondent number 1, 5 and
6.
5 and 6. Pair allowed after effecting service by disseminate, the applicant shall file an affidavit before this court. List the matter on 3rd of July.
Deeply obliged.
Over.
नहीं भेजता है. And sir, that is conceptual. Again, see.
Mr. Son, you have filed your affidavit.
Yes, my lord.
In which paragraph you have stated the fact? Paragraph number 8.
Correct. Tagalog file ang dito. My lord, para 2 of the additional affidavit, my lord.
Yes.
That as per the direction of this honorable court, that this additional affidavit 2 stretches of land situated Nambu area 68.40 hectares and another stretch of land measuring 17.62 hectares respectively under the occupation of the petitioners on the right bank of the Dibang Valley, Dibang River, my lord. So, my lord, please come to my lord 4. The Deputy Commissioner cum Collector Lower Dibang Valley District, Rowing had by notice number this December 8, 2025, addressed to petitioner claims and objections and the objections, and after hearing claims and objections in connection with the assessment of the property, the discussion has been kept on reserve, my lord. So in the both cases, my lord, the Deputy Commissioner has already assessed the properties. So now the same is pending for disposal, my lord. So my humble prayer for your lordship, but I'm totally regretted that I have made a statement before your honor, your lordship, right, that the petitioners, if desires, can forego the land measuring 17.62. My lord, which may be kindly rectified, my lord. And thirdly, my lord, my humble prayer before your lordship, let the matter be, my lord, refer to the Deputy Commissioner for adjudication of the land in question, my lord.
So now the review petitioners have forgone their claim over the stretch of land measuring 17.62 hectares. Is it correct?
Your language says so. Your language? Parent 17. 7, no? I know this is pertaining to implement of the parties. As on today, my lord, the parties have not been implemented.
Mr. Nabam, have you gone through the affidavit filed by the petitioner?
My lord, I'm sorry, my elder brother, my lord, is to tell you, you turn, my lord. What last time I have addressed to your lordship. Because the affidavit which he was need to file, my lord, that was pertaining to 7.62, my lord. As per his oral submission, he said, my lord, his client is no more interested 70.62, right? My lord, that affidavit was need to be filed. But here we have what we have seen, my lord. It's all mixed up, my lord. 86 point, then 17.6. This are all mixed up. Now, paragraph 6, But before that, why I'm saying, my lord, this present, my lord, review petitioner cannot have anything to say on, my lord, 17.62, my lord. I'll just, if your lordship peruse, my lord, the review petition, page number 303, my lord. Right, my lord, this is the, my lord, genesis. Foundation to move a petition for lordship, my lord.
303.
303, my lord. This is the, my lord, general power of attorney, my lord.
Yes.
Your lordship will find all the petitioner, review petitioner names, my lord.
Mm.
Then your lordship may kindly come to page 305. I'll be traveling your lordship because, my lord, has your lordship got it, my lord?
Yes, 305.
Yes, my lord. Schedule. Schedule is very important, my lord. Has your lordship got it, my lord, down below?
Yes, yes.
The boundary of Apali and New Apali areas under the Dambuk Circle, Lower Dibang Valley, District Arunachal Pradesh. Schedule. North India Mountains, South River Dibang, East Malo Ilu and Dibang River, West River Diri, and total area 78 square meter, my lord.
Yes.
Right, my lord? And we are considering only 17.62, my lord. Then why I'm saying, my lord? And if your lordship see, my lord, the descriptions of the schedule, my lord, if your lordship see the notification, my lord, notification point 17.62, my lord.
Page number?
138, my lord.
138.
Yes, my lord. Wait, 138. This is dated 20th June 2025, my lord. Under Body for Act, my lord, section 10, my lord.
Yes.
Then your lordship may kindly come to next page, my lord, 139, my lord. The schedule of land
Yes.
is totally different, my
17.62.
lord. Yes, my lord, 17.62. Schedule of land is different. So he cannot, based on the power of attorney, he cannot have anything to say on 17.62, my lord. The present, my lord, review petitioner, my lord. Their lands are different, my lord. If your lordship see, my lord, north private and community land, south private and community land, east so and so and so and so, my lord. Right, my lord? Then, my lord, after this, my lord, preliminary notification, 20 June 2025, but there is a clause, my lord, paragraph 3, if I correct remember. But within 30 days, my lord, they have to raise claims and objection, my lord.
Page
If your
number?
lordship see, my lord, the preliminary notification, my lord.
Page number?
138, my lord.
138. Yes, yes.
1, 3, 4, 5 paragraph, my lord. Any person, it starts, my lord. Any person who has any objection to the acquisition of land may file such objection in writing to the Deputy Commissioner, Lawat Devengberry, within 30 days from the publication, my lord. They have not done anything, my lord. Right, my lord? Then, my lord, another thing, my lord, that based on this, survey was conducted, my lord, on 25th August 2025.
Page number?
Survey, page number they have not annexed, my lord. I'm sorry, my lord. I don't know deliberately or not, my lord, but I have the records, my lord. Survey and assessment was done under the, my lord, chairmanship of ADC, my lord, Dambuk. Was the chairman, my lord. So survey and assessment report was done on 25th August 2025, my lord. Your lordship may kindly note this. That's this very important. And this survey and assessment report was sent to the Deputy Commissioner by the chairman, my lord, on 26 September 2025. Then based on this survey and assessment report, now Deputy Commissioner sent it to the Director Land Management for government approval, my lord. But you may kindly note, my lord, in survey and assessment, all, my lord, beneficiary lists are there, my lord. Who are the owner of the land, my lord. Now, my lord, this draft award was submitted on 30 October 2025 by the Deputy Commissioner to the Director Land Management for government approval, my lord. Now, government approval was given on 24th November 2025. Till then, my lord, they didn't say anything, my lord. There is no whisper, my lord. There is no complaint, nothing, my lord. Now, if your lordship says, my lord, when, my lord, the power of attorney was executed, only 2026, just to file a petition, my lord. Right, my lord? So that also, my lord, after passing of the order, my lord. Now, when we see, my lord, I have already demonstrated, my lord, the boundary description also different, my lord. Now, once assessment and survey is confirmed, beneficiary list sent by the Deputy Commissioner to the government are approved, my lord, that attend the finality, my lord. After that, there can be no addition and deletion, my lord. Because ADC, my lord, he made the survey report being a chairman of the committee. The report was submitted to the Deputy Commissioner. The Deputy Commissioner, my lord, based on that assessment and beneficiary list, that was sent to the Director Land Management for government approval. And once, my lord, the government approves the list, my lord, my lord, I'm sorry to say, my lord, there can be any addition and deletion, my lord. That attend the finality, my lord. And here is the case, my lord. They come after almost after say couple of. This was 20 November 2025, my approval. And when they approve your lordship, my lord, only 2026, my lord, almost after a year, my lord. So my humble submission, my lord, there cannot be any more disputed, my lord, once the list has been approved by the competent authority, my lord, government, my lord. There cannot be any more beneficiary list, my lord, so far my understanding, my lord. Because that attend the finality, my lord, once government approves, my lord.
And whether those documents are part of the record, not part of the record.
My lord, they have not annexed, my lord. I have the records, my lord. They have not annexed, my lord.
Okay. Can you forward the
My lord,
same
in
to
review
the
petition-
registry of this court?
I'm sorry, my lord. Yes, my lord, I can give, my lord. No doubt about this. I have the records, my lord.
Okay.
Whatever I have submitted for lordship, my lord, this was a document given by the Deputy Commissioner, my lord. I can give it to you, my lord, to the bench assistant so that he can communicate to your lordship, my lord.
Yes. Can you
I can
submit the same today itself?
Yes, my lord. I can do that, my
Okay.
lord. No issue for that.
Yes,
That's why, my lord.
from the additional affidavit filed by Mr. Son, it appears
My
that
lord.
they have not been foregoing the claim over the 17.62 hectares of land.
Exactly, my lord. Exactly, my lord.
Okay.
But that is totally contrary to the records, my lord. My lord, affidavit cannot change the records, my lord.
Yes,
I have
cannot change.
demonstrated. Yes, my lord. I have demonstrated, my lord, the power of attorney, my lord, where the land has been described, and the areas are different. Total square meters are different, my lord. It's 76. We are only focusing on 17.62, my lord. My lord, I can understand, my lord, the review petitioner, my lord, because in another cases are pending, my lord. Maybe, my lord, they have some, being a human being, my lord, heartburn feeling. If I don't get, you also don't get, my lord. You also wait for your turn, my lord. That could be a reason for filing this review petition, my lord. My lord, I would like to defer. My lord, just a minute. My lord, that's why, my lord, this review petition, my lord, is not at all, my lord, maintainable, my lord. So, my lord, I defer the. Just a minute. My lord, now, my lord, the main petitioner, my lord, was before this court almost for a year, my lord. There was a direction from the court to make a survey, my lord. Right, my lord. Even then, my lord, they, my lord, take a long nap, my lord. After everything is completed, now they are before your lordship, my lord. And that has been already settled, my lord, Mihing Laling case. If acquisition process is completed, my lord, it cannot be reopened, my lord. That's my submission, my lord.
Okay.
So my lord, I would like to defer the point raised by my learned friend. My lord, as per this annexure, annexure 1 page, type copy 138, my lord. As per this, my lord, the notification, my lord, after the issuance of the notice and after expiry of the 30 days, my lord, they have submitted the claim and objection, number 1. My lord, kindly peruse annexure, page number 268. This is the, my lord, claims and claim number 2. Name of the claimant, objections, Matim Lingi. He is a petitioner here, my lord.
Page number
68, my lord.
68.
68, my lord. So here, the name of the claimant, objectors, Shri Matim Lingi and others, area of the hearing conduct, stress 2 to 4, 6.98 hectares, date of hearing 39/2025, my lord.
I'm sorry, my, that is different area, my lord. That comes under 86, my lord. Not 17, my lord. I'm sorry, my lord. 86 under one.
So as per the notification, they have complied, my lord. 30 days, within 30 days, they have filed claims and objections. And my lord, kindly to come to my lord, statement of claim and objections, objectors. This is already claim and objections were done by the additional deputy commissioner,
Number 2.
Dambu.
Further considering the primary document in his favor, the claim of the ownership over the land.
These are the old series what the my lord, from 228 to 68 to up to my lord last, my lord, that is up to
Mama, and his they have not challenged it. Sir, Purna wala 185. How can you
up
amend?
to 290.
Which one?
So here,
No,
all the my lord
it's the old one.
land situated at Dambu area was thoroughly conducted by the land management department on various dates with effect from
No, Mr. Swan, have you
39
filed a written complaint with the deputy commissioner?
Yes, my lord.
Where is that complaint?
Not proof beyond.
Masuk na.
Up to the On receipt of the complaint, my lord, the deputy commissioner took up the hearing, my lord.
ADG.
No, deputy commissioner also issued notice. My lord, in amended review petition, my lord, page number 84, annexure 4. This is the notice issued by the deputy commissioner, my lord.
Page number?
84. Annexure 4.
This is stuck from 99. Oh, it can be. Okay, so na page ulta pata.
In interlocutory application, sorry, my lord. Interlocutory application in amended petition, my lord.
Okay.
Amended petition, my lord. 84, my lord.
Yes.
May I read the contents of the notice, my lord? In continuation of the land acquisition proceedings relating to construction of the right bank of road from ADC Moore to Mitun Gate at new Apali and additional facilities area from area slash stress 1 to 4 is hereby notified that the claims and objections regarding rightful ownership over the land notified in acquisition measures 68.88, my lord. My lord, kindly clarified it, my lord.
Which one? Because our pagination is not matching, sir.
No, Mr.
Number
Son,
82.
Mr. Son, we are concerned with 17 point acres of land,
Correct.
not 68.88 hectares.
Right.
My lord, by this notice, my lord, it has been clearly laid down that 68.88 hectares, my lord,
Different land again. This is different land.
shall be heard by the undersigned and on 29/12/2025, my lord, within the, my lord, specified date, my lord.
No, no,
And
in
from this
respect
day-
of 17.62 hectares of land, where you have filed your claims and objection.
Doma. There is no record.
I'm sorry, my lord.
If there is no document to substantiate your submission, then
My
why
lord.
should we not dismiss this petition with cost? Is it not abuse of the process of the court? Mr. Son,
My lord.
why should we not dismiss this petition with cost? If there is no document to substantiate your claim, okay.
My lord, therefore, my lord, actually, last occasion, my lord, I prayed before this honorable court to forego the 17.62, my lord, and stick to the, my lord, 68.40, my lord.
Very fair, my lord. As a counsel, session counsel, Son sir has rightly submitted. Because he cannot go by with the direction of his client. He is being duty bound as a court officer. He is rightly assisting the court, my lord.
So therefore, my lord, total area
Mr.
would
Tara,
My lord,
have you seen the affidavit, additional affidavit filed by Mr. Son?
my lord, I thought of making a small submission supporting the argument advanced by learned additional AG, because there is no record to show that they have filed any claim and objections. And whichever paper, my lord, they have shown, there also the additional deputy commissioner has given an audacity to them, and his reject has been claimed in 2 areas, my lord, that I want to show. And then, my lord, I want to raise a objection. My lord has passed one order in Bhavin Chandra Vaishya versus Punjab National Bank and others, review petition number 58/2022. So this also I want to cite. If my lord can give me 5 minutes. So my lord can give me a small moment. May I start my argument with this?
Yes, yes.
Yes. So, sir, take your 6. My lord, the learned counsel for the review petitioner referred to those pages. My lord, will kindly have the amended review petition.
Page number
May I
78.
request page 1, second amended review petition, my lord.
Page number
Page number 169, my lords.
169. Yes.
My lord, see this first claimant number 3, my lord,
Yes.
is Maitem Lingi and others, my lord.
Mm-hmm.
Area of hearing conducted is stretch number 2224, that is 6.9 hectare, my lord. Statement by the claimant, my lord. The submission of Maitem Lingi and others in the same are submitted earlier for stretch 6 on 29/9/2005, and this is altogether a different area, my lord. He claims that he is bona fide land owner of the land measuring 6.95 hectares. He relies on the various documents that he has submitted to substantiate his claims over the land under consideration for acquisition. He also claims that the present area under consideration for acquisition fall under New Apali area. This is Avari's other side of the river bank, my lord. Now kindly see, my lord, what is most important is, my lord will find at page 170. Conclusion. My lord, kindly come to decision number 5. The claims made by Sri Maitem Lingi and others are based on the fact that several NOCs, certificates, etc. have been issued in his favor. It is matter of the fact that his name figure verification under the chairmanship of Sri Rakesh Tacho, CEO Desali, but the point to be noted is that he is recorded to be the representative of Mimi clan. My lord, kindly mark this. Kindly mark this sentence. Representative of Mimi clan, my lord. And these, my lord, contradicts with page 303, my lord. Kindly come. Thereafter, I will conclude the part, my lord. That power of general power of attorney, my lord.
Yes.
Kindly see, my lord, the first is Lokep Lingi, son of late G. Lingi, aged 47 years, permanent resident, so and so, is a brother. He is a younger brother, my lord, of the review petitioner. Then number 2, Newton Lingi, aged about 45 years, so and so, Divang Veli is also the younger brother of the review petitioner, petitioner, Maitem Lingi. Then, my lord, most interesting part starts from serial number 3. Asena Lingi, son of Sri M. Lingi, my lord. This is a Maitem Lingi only, he has made it shortcut. Lingi aged about 31 years, my lord. Then Komla Mito, wife of M. Lingi, 52 years, my lord. Same. Number 5, Miss Lingi, Lakshmi Lingi, M. Lingi, same, 32 years, my lord. Then number 6, Yamini Lingi, my lord, daughter of M. Lingi. Miss 7, my lord, 304. Miss Amaya Lingi, daughter of M. Lingi. Sri Ajo Lingi, son of M. Lingi, my lord. Same person. Now, my lord, the area which they have described is Apali. My lord, kindly come to page, next page, 305, my lord. In the schedule of the land, boundary, my lord. A while ago, my lord, learned additional AG has referred to the notification, my lord.
Yes,
Kindly
yes.
see, the land is different and here they are different, my lord. It's a new boundary of Apali and New Apali areas, Dambuk Circle, my lord. Kindly mark this. And my lord, next page, my lord, 308 is very important.
Yes.
My lord, first thing, my lord, the read petition 352/2025 was concluded on 19/3/2026. My lord will mark that. The read petition number 352/2025 was concluded by order dated 19/3/2026. Butting in, my lord, commensurating my argument kindly see the date and serial number, my lord. Kindly see. Date, my lord, bottom. Date 28/3/2026. This is a document created much after thought, my lord. And the litigation was going on since 2025, and he was sleeping quietly, and he did not file any claim and objections in terms of that notification on 17.62. My lord has put a specific question to the learned counsel for the review petitioner as to whether you have filed any claim and objection before the authorities. The answer is no. You are stopped. Principle of estoppel will come. Then, my lord, 45, my second limb of argument, kindly see that page, my lord, kindly come back to page 170, where the additional deputy commissioner has given so much of audacity to him. The claims made by Sri Maitem Lingi and others are based on the facts that several NOC certificate, etc. have been issued in his favor. It is a matter of fact that his name figures from the very first report of the project affected family verification under the chairman of so-and-so, Desali. But the point to be noted is that he is recorded to be the representative of the Mimi clan. So Mimi clan is, my lord, which my brother Gara is representing. Garam is representing. Representative, my lord. Why he should represent us? Can he claim any title right on the basis of this analysis? That has been withdrawn long back in another project, my lord, where compensation was drawn. That his name is addressed in land honor. Also, deed of revocation, my lord, this is also recorded by the learned additional deputy commissioner. Kindly see that his name is addressed as the land honor. Also, number 3 of deed of revocation of general power of attorney by Sri Bota Mimi, my lord. I am right. And 2 others, annexed in the annexure of Bota Mimi and others, page 28-34, in respect of Maitem Lingi, corroborates that he had represented the Mimi clan, my lord. Now he is no more our representative, my lord. However, it is made clear that this is no way nullifies the claim of Maitem Lingi as the land owner of the land under consideration. As such, the point number 2, 3, and 4 of the inference above needs to be considered. Further, my lord, this is the clinching point in my favor, my lord. Further, considering the absence of any primary documentary evidence in his favor, the claim of ownership over the land is not established beyond doubt. Now, therefore, my lord, the review petitioner has no answer. The second, my lord, kindly come, another page I'll show, where on the second occasions, his hearing was flatly rejected by the additional deputy commissioner. Kindly come to page 185, my lord. Amended, sir, amended, 185.
Yes.
My lord, kindly see claimant number 4 is item number area 2 stretch 6. 11 point, what is this, Taja? I could not see it properly, sir. 11.84 plus 1.30 hectares, my lord. When the hearing took place, my lord, date of hearing was on 29/9/2025. The place conference hall is ADC Dambuk, my lord. The same thing, my lord, it is a verbatim, my lord, where his claims have been rejected by the additional deputy commissioner. My lord will come to page 186.
Yes.
Decision, my lord, bottom, from bottom, line 3 above, as such, my lord. Same thing is written, my lord, because he represented power of attorney and all those things is there. It is a verbatim, my lord. Verbatim of the earlier this thing, my lord. As such, the point number 2, 3, and 4 of the inference above needs to be considered. Further, considering the absence of any primary documentary evidence in his favor, the claim of ownership over the land is not established beyond reasonable doubt, my lord. So therefore, with this, my lord has seen that power of attorney they have manufactured, and he is no more the representative of the Mimi clan, which is represented by my brother Taja Garam. So he has successfully manufactured this page number 303, power of attorney, which are the family members of the review petitioner. So he has not approached this court with the clean hands, my lord. He never approached this court with a clean hand, my lord. Now, my lord, second limb of my argument is on the maintainability of the review petition itself, my lord. See, my lord will kindly see, the present petition fails to satisfy the foundational prerequisites of Order 47, Rule 1 of Code of Civil Procedure, 1908. Now, here, my lord, on perusals of the earlier review petition and the amended review petition and subsequent, my lord, affidavit which the review petitioner has filed, here I could not find any documents that can satisfy this court. Well, see, the review petitioners have failed to pinpoint any error apparent on the face of the record in the final order dated 9/3/2026, passed in WPC number 352 by this court. It was a consensus by the Mimi and the Mimi clan in the Narkolingi, my lord, the Lingi. Two read petitioners who have consented before, my lord. So now see, my lord, now, my lord, I rely on a judgment passed by Lordship only. Then another one. My lord, I'll read out and I'll transmit this small note through the rest. दूसरा एक Gauhati वाला. हाँ, my lord, this Soven Mikri versus Nalin Mikri, SOBEN Soven, MIKIR versus Sri Nalin Mikri. And another.
You give me the petition number.
Yeah, petition number is, my lord, IA Civil.
Yes.
3036/2025. बता दे. Here, my lord have invoked this famous judgment. My lord, here it says, while dismissing this, my lord have said, my lord, in this, the Bhaven Chandra Vaishya case and Punjab National Bank and review petition number 52, dispose of so and so, authoritatively reiterated the narrow scope of review. In that judgment, his lordship accepted the settled position of law that a review petition is by no means an appeal in disguise, whereby an erroneous decision is reheard. Well, as I have categorically submitted, neither in the first review petition nor in the second amended review petition, and a while ago also, my lord, have specifically put a question to the learned counsel for the review petitioner as to whether you have filed any claim and objections over 17.62. The answer is no. And the learned counsel for the review petitioner could not demonstrate, yes, they have done this. Therefore, my lord, on the basis of this, my lord, just I indicate the paragraph of this judgment. My lord, I'll just transmit this entire thing. I'll indicate this paragraph and then I'll send it to the court, my lord.
Okay.
It would be 7.4, my lord, that paragraph 7.4 is the judgment, my lord. I'll transmit, my lord, again.
Okay.
Although my lord has rightly held that, and this was also the same thing. Now, my lord, kindly see, the review petition is self-destructive, my lord. A third limb of my argument is the review petitioner is entirely self-destructive, as because the petitioner rely on the proceedings of Additional Deputy Commissioner ADC Dambu, which in fact thoroughly demolished their claim of ownership, my lord, which I have referred to a while ago, my lord. My lord, just I'm indicating the para again, where ADC has explicitly recorded at pages 169 and 170, which we read together, my lord, pages 185, 186 of the review petition itself. My lord, the competent revenue authority conducted an inquiry twice, found based on evidence that Maitem Lingi possesses absolutely no primary documentary evidence of ownership, my lord. Now, secondly, my lord, that particular judgment, my lord, which I referred to a while ago, is all about the unclean hands, suppression of the material facts, my lord, and manufacturer locus, my lord. Primary condition of a review, my lord, is aware the discovery of a new and important matter, not the applicant's knowledge, is fundamentally missing here, my lord, in this case. Maitem Lingi, my lord, the review petitioner has participated in all public hearings before the ADC Dambuk. He had complete prior knowledge of the litigation and had been previously filed review petition also in review petition number 19/2026, my lord. Now, my lord, see the fabricated locus. What is that fabricated locus? The fabricated locus, he attempted to cure his lack of locus standi by executing a general power of attorney on 28/3/2026, exactly 10 days after WPC number 352/2025 was disposed of, exclusively, my lord, utilizing his immediate family members as principals. Well, there are catena of judgments which we need not to refer also. A person who approach this court without clean hands does not entitle for any relief. And these review petitions should be dismissed with heavy cost, my lord, because this is national project. Now, my lord, kindly see, the review petitioner is riddled with fatal procedural anomalies, my lord. What are those, my lord? The petitioner cites inconcilable land area figures ranging from 16.62 hectares to 68.88 hectares and now 68.4 hectares as per the new affidavit, my lord.
Yes.
Demonstrating that the petitioner themselves are unsure of the extent of the land they claim. If you are not aware of the exact land where it lies and it is owned by you, where is your locus? Therefore, that, my lord, 28, the locus which they have created by means of affidavit, my lord, is a real term, my lord. If I have to go through all those things, my lord, I'll not say, my lord. So therefore, my lord, this review petition should be dismissed, being devoid of any merits and material facts, suppression of the material facts, my lord, and unable to answer my lord's specific query as to whether you have filed a claim and objection before the deputy commissioner relating to 17.6 hectares of land or not. The answer was no, my lord. So therefore, my lord, the deputy commissioner may kindly be directed that release the compensation amount in respect of the 17.6 to the petitioners and respondents in read petition number 352/2025, which was concluded in 19/3/2026, my lord, on the basis of joint application, my lord.
Okay.
Filed by both the parties, my lord. So because they have resolved it, my lord. That much, my lord, submission I advance. My lord.
Okay.
And
Okay.
May it please worship?
Yes.
My lord, my learned friend has submitted all the documentary arguments on Barbelli, my lord. There is no any written objection submitted before the court in pertaining to the review petition or interlocutory application. So from the record, it has revealed from the RTI that they have not claimed any land, as my friend has shouted, like at the top of the voice, that with reference to your RTI application regarding a land acquisition for construction of right bank of road from ADC, please, my lord, Annex 2 of my amended review petition, my lord, page 26, my lord. This is the RTI obtained from the
Page 26 of your review petition, amended. Start from 99. No, start from 99.
Khibu Dole, District Land Revenue and Settlement Officer, Lower Dibang Valley.
Page number is not telling, my lord. Amended starts from 99. This is review amendment, start from 99. Now what case is this is amended, this is not amended.
On the sequence one, that's why. This the other ones.
Better check your page number, internal, external, whatever, maybe check. See amended gonna A. Amended.
No, 4. Yes, this is the 4.
Amended. What do you call it?
4. Amendment 4. 4.
Number can be.
It should be.
This is review petition, this is amended, then you have filed 3 petition, right?
Yes.
One is, this is affidavit.
Petition.
Anything else? Okay, so kita penalty pa mo eh. First, second, third.
Yes, what is the page number?
Amendment 4 number.
Yeah.
My lord, the RTI, my lord, Annex 2, page 26 in my amended petition, my lord, interlocutory application number 82.
Amended petition, page number
26, my lord.
26.
My lord, this is the RTI issued by the, my lord, reply issued by the District Land Revenue and Settlement Officer, my lord.
Is it Annexer 1?
Reference Annex 2, my lord.
Page number 26 is the Annexer 1. 20. Yes, 28 is the Annexer 2.
Is it, my lord, dated
26 March 2006?
Yes. 20.
So, my
Page number
reply-
28 is the letter.
Reply to RTI. Reply to RTI, my lord.
Yes, a reply to RTI.
May I read, my lord?
Yes.
With reference to your RTI application regarding land acquisition for construction of right bank of road from ADC Mode to Mithun Gate at New Apali and additional facility area measuring slash stress 1 to 6 measuring 8.82 hectares. I am to furnish the following, my lord. Within that 68.82 hectares, my lord, copy of decision of public hearing stress 5 to 6 fixed on 29/9/2025 by ADC, my lord, where the petitioner appeared before the ADC, my lord. Dambu are enclosed as Annexure A and Annexure B. And number 2, copy of decision of public hearing stress 1, 2, 3, and 4 fixed on 30/09/2025 by ADC Dambu are annexed, enclosed in Index C and Index D. Copy of assessment report of horticulture is enclosed in Annexure E. Please refer to this number. So, my lord, in person to this RTI, it has been revealed that.
My lord, sorry for the interruption, my lord. This is nothing to do with 70.62, my lord. This is 68, my lord. We have nothing to do
68,
with.
yes.
Yes, my lord. We are concerned with 70.62.
So, my lord, as per the decision arrived by the Deputy Commissioner, the opposite parties' documents were already nullified as there is no any proof of the ownership. Page number 32, name of the claimant, objection, Bota, Mimi and others, area. Bota, Mimi, the submission of Bota, Mimi and others is included as Bota, Mimi, page number 1 to 82. He claimed that the land measuring 38.1 hectares of New Apale are his ancestral land, as they are the direct descendant and great grandchildren of the late Ahong Mimi, the original owner of the land, original land. He claimed that the land has been in their peaceful possession and enjoying since time immemorial, recognized and acknowledged by the Gaon Buras, elders, and traditional institution of Dambu. My lord, in the as claimed by them, my lord, the respondent, there is no any documentary evidence. Neither it was submitted before the ADC nor before this honorable court in a written objection. So, my lord, the claim made by the minor respondent are also in a vague claim. There is no any land as claimed by the respondent parties. If they want, they should come in a written objection. It is their land and the petitioners are claiming in a bogus manner. But on the basis of the barbell submission, the learned court may not consider the submission made by the my learned friend. So, my lord, as I referred earlier also, my lord, the 17.62, this may kindly be forward because it is the record which does not give any authenticity of the land, my lord. So, my lord, only the matter of fact is that within the area of 68.88 or 40 hectares, that is common to all, my lord. Let the deputy commissioner decide the land, who are the actual owners and who are the beneficiaries of the land.
No,
That may
Mr.
be, my lord. My lord.
Mr. Son, this is not a writ petition, this is a review petition.
My lord.
So such kind of direction cannot be passed here.
This is correct.
We are, Mr. Son, we are concerned with only the order dated 19/3/2026. Whether the same can be reviewed under the provision of law or not.
My lord, this is a
This is not a writ petition.
Yes, correct.
Anyway, we are reserving the order. Mr.
Please, your lordship.
Nabam, you please
Yes, my lord, I'll come. Yes,
you
my lord, I'll
forward
get
the documents to the court master. And
my lord,
Mr. Tara also forward the decision of this court.
Correct.
Yes.
My lord,
Yes,
my
Mr. Gaurav, you
Yes.
want to submit?
Yes, Lordship. From the amended review petition itself, Lordship, to substantiate the submission advanced by my learned seniors, Lordship, additional AG and Mr. learned senior counsel, Mr. Tiditara, Lordship.
Yes.
Lordship, to substantiate the argument advanced by the learned seniors, Lordship, Lordship may kindly come to the page number 38 for a moment, Lordship. 138, Lordship. Amended review petitions, Lordship.
Yes.
Yes, Lordship. Lordship, from the second paragraph, Lordship,
This will be this will clear more crystal clear also. Whereas the executive director, DMP, NSPC Rowing White letter dated so and so has requested expedite the process of land acquisition for an area measuring 17.62 hectare on right bank of the construction dam structure, Lordship. And yes, Lordship. And this is specifically for the 17.62 hectare, Lordship. And
Yes.
whereas the review petitioners, Lordship, the hearing took place before the ADC Dambuk, Lordship, is for the 68.88 hectare, Lordship. For that, Lordship may kindly come to the page number 202, Lordship.
Yes.
Yes, Lordship. This letter, Lordship, has been issued by the Deputy Commissioner, Lordship, to the review petitioner, Lordship. Your Lordship may kindly see that. In pursuant to DC order number so and so, that conduct claim and objection, whereas your claim of rightful ownership over the land, notify for the acquisition measuring 68.88 hectare for the construction of right bank road from ADC Mora to Mitun Gate at New Epali area, Lordship. The area is completely different, Lordship. And this notice has been issued to the review petitioner, Lordship, for the 68.88 hectare, Lordship, not for the 17.62 hectare, Lordship.
Okay.
And if your Lordship will see the page number 204 for the another notification which has been issued by the competent authority for the land acquisition process, 68.88 hectare, Lordship will find it page number 204, Lordship.
Under Balipura.
204, yes.
204, Lord. From the second paragraph, Lordship. Whereas the governor of Arunachal is satisfied that land measuring 68.40 hectare mentioned in the schedule below is need for the public, namely for the construction of right bank road from ADC Mora to Mitun Gate at New Epali under Dabuk subdivision. 17.62 hectare is acquisition process has been took place at the construction site, Lordship. And 68.88 hectare and 68.40 hectare is for the road construction, Lordship, to reach the construction site, Lordship.
This is for dam structure.
Yes.
Construction of
Construction. So my humble submission is that, Lordship, two acquisition process has been took place, Lordship, and we are confined with the 17.62 hectare, whereas the review petitioner is come with all the documents which substantiate for his submission, Lordship, is only for 68.88 hectare, Lordship. And your Lordship has rightly pointed out that the Lordship cannot issue the direction to the Deputy Commissioner to the claim and objection in 68.88 hectare, which is another course of action, Lordship. For that, he has to file a new writ petition, Lordship. And so far, this review petition is concerned, this Lordship, this is only comes from 17.62 hectare, Lordship.
Okay.
My humble prayer is that, Lordship, since the legitimate order, Lordship, despite the order passed by this honorable court from the last 8 months, we are waiting for the payment, Lordship. So this review petition may be dismissed, Lordship, and the direction may be issued to the Deputy Commissioner to issue the compensation amount as per the joint application filed by the petitioner, Lordship, in the first petition, that is WPC 352, Lordship.
Okay.
That is my only humble submission, Lordship.
My Lord, two things, my Lord, I forgot to inform this honorable court, my Lord. My Lord, otherwise, my Lord, I'll be lacking in my fairness before Lordship, my Lord. My Lord, assessment and award, my Lord. When it was sent to the, my Lord, to the director, land management for government approval, my Lord. My Lord, although, my Lord, there is a reflection of the petitioner's claims and objection, my Lord, but that was nullified. Number two, my Lord, rightly or wrongly, Deputy Commissioner, my Lord, under 64, my Lord, reference, my Lord, that I think, my Lord, that is the right course of action, because if there is any, my Lord, dispute, my Lord, reference court cannot decide, my Lord, but my Lord, title, my Lord, regarding, my Lord, reference can be decided only pertaining to, my Lord, land measurement dispute, then, my Lord, quantum of compensation, my Lord.
my lord. My lord, these things, my lord, I have to inform the court, my lord, because there is a letter from the Deputy Commission, my lord. Otherwise, I'll be failing on my part, my lord.
Okay.
My lord,
To that respect, Lordship, just for the few minutes, Lordship. So far as, Lordship, the reference code is concerned, Lordship. As per the Lara Act, Lordship, Section 64 is clearly stated that, Lordship, the Deputy Commissioner cannot send the disputed matters to the reference court by suo motu, Lordship. It has to be received from the letter written by the parties who are being disputed in that particular property, Lordship. Section 64, if your Lordship may allow me, Lordship, I can read it, Lordship. The small paragraph. that is
Mr. Gaurav,
such-
not necessary, not necessary. Okay.
Lordship.
Okay.
My
Yes,
lord, my
Mr. Swan.
last prayer, my lord, last prayer that when the matters are in a disputed question, let the matter be referred to the, my lord, the civil court, my lord.
Pardon?
This court will participate in the civil court. That is the, my lord, the last option.
No, that
Because there
option
is
is
a claim
available
and
to you.
counter claims.
We are only concerned with the review petition.
Definitely, my
Okay.
lord, definitely. Because there is a claim and counter claims, my lord.
Heard. Mr. T. Son, learned counsel for the petitioner. Mr. R. S. Nabam, learned additional advocate general for the state respondent. Mr. T. Goram for respondent number
1, 2, 3, Lordship.
1, 2, 3. Mr.
Two,
T.
three.
T. Tara, learned senior counsel, assisted by Mr. T. Goram. Learned
No, my
counsel for
lord,
the
this is Elijah Nich.
Elijah.
Elizabeth Nich.
Okay.
Elizabeth Nich.
Okay. For the respondent number
11 and 12.
11
11 and 12.
11 and 12. Argument concluded. Order reserved.
Much obliged.
Deeply obliged, Lordship.
Really, no?
Oh, yes.